Speaker, and I'm very grateful to the previous Speaker, Mr Mallard, for pointing out that there are differences between this government and the previous government. Indeed, there was a really speedy process which he claims was quite unfair, and I want to contrast that with the previous Prime Minister Clark's support of one Taito Philip Field, when she stood up and defended him and said all that he is guilty of is working hard for his constituents, parading around South Auckland with Mr Field in complete defence of the indefensible. Well, if that's the contrast between this government and the previous government, bring it on. I'd really like you to talk as much about that as you can. He also raised the chagrin that the CTU had over the Prime Minister not making any heads up to them. Well, here's the news. Here's the news, Mr Speaker. We now have a Prime Minister that doesn't have to go cap in hand to the unions every time they want to change employment law. They're not beholden to the unions. There is a very sound relationship, and if the President of the CTU got a bit angry about that, well, I'm sure she'll get over it. But this is a government that thinks for itself, that doesn't have to go to the CTU every time it wants to make changes. And that's a significant difference for employment relations in this country. I wasn't there, I don't know what he said, but I know he doesn't have to go cap in hand to Ms Kelly every time he wants to make changes to employment legislation. Now, I want to drill into some of the matters that came up in Select Committee, and in particular the 90-day probation period. And again, I thank Lynn Pillay for providing an excellent example of how the 90-day probation period is going to work, when she quotes the fellow who has lost his job because he claimed that he had put too much aioli, I think it was, sauce in the pasta. Here's what she didn't say. The 90-day probation period will not apply in a situation like that. It may be actually before the court, so I'm not going to talk about it specifically. But a person who does not sign an employment agreement cannot be subject to the 90-day probation period. So yet again, the CTU have scored another own goal. This is an example of the process working, not of the process not working. No one who does not sign an employment agreement can have the protection of the 90-day legislation, which has been in place for a couple of years now. And as the Department of Labour pointed out, they've done some very good research into how effectively it's working. Now, members on the other side can take a glass three-quarters empty approach to what's going on. But I want to point out that a great number of those people who were taken on by small businesses under the 90-day provisions would not have been employed were it not for that opportunity. It's just too hard otherwise. What's really interesting also is that of all of the small and medium-sized enterprises that were able to use that legislation, only half of them did it. Only half of the organisations. So they didn't all rush out and slap 90-day probation periods. They thought very carefully about when it would be appropriate, when it was okay to take a chance on an employee who might be marginalised, who might be coming back from a long period of unemployment, who might be a new migrant to this country, and give them a chance. But of only the half of the employers that used that provision, they didn't even use it for all their staff. They only used it for just over half of those staff. So for all the wailing and gnashing of teeth, only just over a quarter of the people who could have been employed under a 90-day probation period were. The rest were employed permanently. And here's the good news. Nearly 80% of them still have their jobs. Nearly 80% of them are still employed. For those that weren't, they weren't all sacked. Some of them left of their own volition. For some, it simply didn't work out. And that's one of the consequences. Enough to make the survey scientific. Nobody is questioning the validity. But I do understand that members on the other side are worried that they didn't speak to employees. Well, it's not the employees that are doing the 90-day probation period employing. It's the employers. So when you're talking through the employer, I never said that. Nobody's putting words in my mouth. Of course they count. That's why we're doing this. And I have absolute confidence that when this is extended, you're going to see similar discernment by employers. We had the ASMS, the junior doctors, come in and say, oh, we're all going to be put on 90-day probation periods. Well, it's nonsense, because employers are much more discerning than that. Because I've been one, I know what they're like. And as Lynn Pillay said, I want to quote her in her second reading speech, There are many, many good employers, just as there are many, many good employees. But what she doesn't say is what Labor really think, but they don't say out loud, is that they've got no problems with there being a few errant employees, and why on earth would we want to wrap law up around controlling errant employees? But when it comes to errant employers, lock them down. Put all the red tape around them you can, and suffer the consequences of all the good employers having to put up with that. Yeah, she just said yes, exactly. She's admitted it. Why wouldn't she? It's what she believes, that all employers really are earned. And so we're going to lock them up in red tape. Well, I don't think so, Mr. Speaker. I think they deserve much more confidence in their ability to grow this economy, to employ staff, and to have the flexibility that this bill will give them, and I support it.
Well done. Well done, bro.
The question is that the amendments recommended by the Transport and Industrial Relations Committee by majority be agreed to. Those of that opinion will say aye.
No.
Contrary? No. The ayes have it. Party vote? Party vote?
Yes.
The clerk will conduct a party vote.
Why should we hurry for you?
Order.
New Zealand National.
58 votes in favour.
New Zealand Labour.
41 votes opposed.
Green Party.
9 votes opposed.
ACT New Zealand.
5 votes in favour.
Maori Party.
E rima ngā pōti kore whakai.
Progressive.
1 vote opposed.
United Future.
1 vote in favour.
Honourable Chris Carter.
The ayes are 64, the noes are 56. The motion is agreed to. The question now is, the amendment is agreed to. The question now is that the motion be agreed to. Those of that opinion will say aye.
Aye.
Contrary, no.
No.
The ayes have it. Party vote. The clerk will conduct a party vote.
New Zealand National.
58 votes in favour.
New Zealand Labour.
41 votes opposed.
Green Party.
9 votes opposed.
Maori Party.
E rima ngā pōti kore whakai. ACT Party.
ACT New Zealand.
5 votes in favour.
Progressive.
1 vote opposed.
United Future.
1 vote in favour.
Honourable Chris Carter.
The ayes are 64, the noes are 56. The motion is agreed to.
Employment Relations Amendment Bill number 2, second reading.
This bill is set down for committee stage forthwith. I declare the House and Committee for consideration of the